Incompetent to stand trial or insanity defense. There have been a number of local murder defendants whose attorneys have raised concerns about their clients' mental competency.
Often they will pull in an expert like me, like a psychologist or psychiatrist, to render a second or even a third opinion to the court if there's disagreement about the first one or even the first two.
News4Jax reporter Eric Abenier is joining us live from outside the Duval County Courthouse, where a handful of those cases have yet to begin in trial. Eric?
Yeah, we're looking at 5 high-profile cases, 4 of which possibly involve the death penalty. And the attorneys representing these defendants have called into question their clients' mental health.
First chair.
William Broyles is facing a possible death penalty in the triple murder of his wife and 2 grown children in Nassau County. To date, he has undergone 3 psychological evaluations. 2 psychologists say he's not competent to stand trial, so a court hearing is to be held to update his status. Jonathan Keeley of Jacksonville is also facing a possible death penalty for the murder of his niece, Ayanna Sawyer. He's getting a psych evaluation ahead of his trial. Leroy Edwards was charged in the murder of a man trying to retrieve a company truck after Edwards was fired, and a subsequent shootout with Jacksonville police. A mental competency evaluation was ordered. Terrell Lewis was charged with 4 murders in 2 separate cases. According to this court document, a mental competency evaluation was done, and the psychologist determined Lewis is not competent to proceed in a trial. And Pamela Cabrera was charged with manslaughter in the death of her 5-year-old daughter. She has a history of mental health problems. Her attorney filed this notice of intent to rely on an insanity defense. Her attorney is also asking for a mental evaluation. And there are others who are also asking for mental evaluations, which begs the question as to why we are seeing so many murder cases in which defense attorneys are filing motions to have their clients evaluated. This is why we turn to forensic psychologist Dr. Justin D'Arenzo. He's been called to evaluate a number of defendants facing death row.
It's hard to know why we're seeing an increase. Sometimes there's a contagion in the system where people are talking to each other and they're using these same pleas, but it's probably a strategy to delay one's case.
But if the strategy is to delay a case or avoid being sentenced to life in prison or the death penalty, Dr. D'Arenzo says one true fact still remains.
Only 20% of people are actually found to be incompetent after an evaluation.
What does that tell you?
Well, it says that most people are faking being incompetent.
Can you right off the bat tell when somebody is faking it?
Typically I can, because I usually have a case file already that I've reviewed and I've talked to the attorneys, but that's not always the case.
A mental evaluation can take up to 3 hours to complete, and in some cases, there's more than one evaluation required. And sometimes there are disagreements over the results of those evaluations, which can once again slow down the judicial process and delay the case. Dr. D'Arenzo says insanity and incompetency pleas often get a bad rap because they are overused and abused, but he also says it's a necessary tool because there are defendants who are legitimately incompetent or insane. Reporting live from outside the Duval County Courthouse, Eric Abenier, Channel 4, the local station.
Eric, just briefly, what is the difference between being incompetent to stand trial versus being labeled insane?
Really quick, if a person is incompetent to stand trial, that basically means they are mentally incapable of understanding the legal process that is against them. If they're going with an insanity defense, it's basically a way of saying that they are admitting guilt, but saying that they're guilty of a crime because of their mental health. Kent?
All right, Eric Abenier reporting live at the courthouse tonight. Thank you, Eric.